Speaking of doing it, Kelly wanted me to make a few remarks, less in term with this theme, but more specific political remarks. So I did want to, tell you guys that there's a midterm election coming up. And when we're talking about ways we can make change, obviously one of the most practical ways is through voting. This midterm election coming up in November, while it doesn't hold specific significance to many of you living here in Missouri, it does hold very serious, perhaps even historic significance and implications for several states, because there are going to be voters in several states that are voting on a number of ballot initiatives this year, all of which have the ability to really move forward this issue in a serious way, one of which has the ability to really be a game changer. So I just want to really quickly run through those. I feel I'd be remiss to not talk about what's going on there politically. We have ballot initiatives in 4 states. South Dakota the voters of South Dakota will be voting on Initiated Measure 13. This is a medical marijuana legalization measure. Were this to pass, an authorized patient in South Dakota would be able to possess up to 6 marijuana plants for their own medicinal use. They'd be able to possess 1 ounce of marijuana at one time if they had a doctor's recommendation and they were diagnosed with one of a series of clinical conditions. South Dakota is the only state where a medical marijuana legalization bill was on the ballot and lost. So this is actually the second time around for South Dakota. About 4 years ago, a similar initiative lost 48-52. It was a very close vote. So we believe there's a lot of significance in going back to that state and trying to right that wrong that occurred a few years ago. Oregon has an initiative on the ballot, Initiative 74. Oregon is a state that has had legal medical marijuana now for over 10 years, and it's estimated that about 40,000 people in Oregon possess legal authority to use marijuana as a medicine. Initiative 74 would expand Oregon's existing medical marijuana law to allow for the private ownership of facilities to commercially produce and dispense marijuana to patients that have legal protections in the state of Oregon to use marijuana. This will only be the second time an individual state has voted on the question, not of legalizing marijuana, but legalizing the commercial production and distribution of marijuana. Maine voters 2 years ago voted on a similar proposal. They approved that proposal, and now the Maine Department of Health actually licenses facilities to grow and produce marijuana to distribute to patients that have authorization under the law to use it. Colorado and New Mexico are also 2 states that have licensed by the state medical marijuana facilities that grow and sell marijuana. Rhode Island and New Jersey and Washington, D.C. within the next 6 to 8 months are also supposed to have licensed dispensaries for these same purposes. Arizona has Proposition 203 on the ballot. This is also a medical marijuana proposition. This would allow, once again, patients to use marijuana with a doctor's recommendation. It does set up a dispensary system within the state where there would be licensed facilities to grow, produce, and distribute marijuana for patients that were authorized to use it. Patients would have the option to either grow their own marijuana or not, depending on their location in the state. The idea being if you're within 25 miles of a dispensary, you would not have the ability to grow, but if you were further away from that, you would have the ability to grow. That was a very controversial language. Several groups that were involved in drafting that language, there was a very strong division. Normal fell on the side of the group that was we were not pleased about that language. We did not like the idea of taking the home grow right away so quickly, but in the end, the language that is on the ballot will include language that says you have to be living within 25 miles of such a facility in order to be able to grow your own marijuana. Arizona is a very tricky state to do an initiative in. Some states, when you run a state initiative, the results of the initiative are binding. That means the only way to change or alter those results is to have another initiative go on the ballot. that actually undoes what the first initiative did. That's not the case in Arizona. Arizona's statewide initiatives aren't binding. The legislature can literally ignore the entire initiative. It can pass and the legislature can say, tough shit, we don't want to do any of these things, and they have the power to do that. Some people may remember in 1996, Arizonans passed an initiative regarding medical marijuana law reform, also had to do with sentencing of nonviolent drug offenders. The Arizona legislature over the next 2 years literally stripped every provision in that initiative and just undid it. So I'm not even convinced if you pass Prop 203 in Arizona, what's to stop the Arizona legislature from simply saying, hey, we didn't want to do this 14 years ago, we're not going to do it now. But the belief is it's conservatively enough written that this time they may let it go. So then the fourth state that has an initiative, and this is the game changer, folks, this is California, Prop 19. This is the Control and Tax Cannabis Act. This is the game changer. This is the initiative that, and it's not hyperbole to say this, this is the most far-reaching marijuana law reform that's been voted on anywhere in the world. Not just in the United States, anywhere on the planet. If Californians vote yes on 19, marijuana will have a more liberal legal status in, say, California than, say, the Netherlands. People don't tend to think of the Netherlands as having restrictive marijuana policies, but they will in comparison to the policies that will be set in California if Proposition 19 passes. Proposition 19 will do two significant things, one more significant than the other. The first thing it will do is it says that if you're over 21, the possession of marijuana in private is legal. Not depenalized, not quasi-legal, not decriminalized, legal. It is lawful activity if you are over 21 to possess an ounce of marijuana in private. We do not have a standard anywhere, really, right now, where we simply say possession of marijuana is lawful. Even in states that, like a state like Maine, that has very strong decriminalization laws on the books. In the state of Maine, you can possess up to 2.5 ounces of marijuana, and it's a civil infraction. No arrest, no threat of a criminal record, you don't even have to go to court, you simply pay a fine. But the marijuana is still considered contraband. Police are still going to forcefully take the marijuana from you because it is illegal. That's not the case in California, were this to pass. The marijuana is legal. Prop 19 also says you can grow marijuana in your house if you're over 21, and that is lawful activity, as long as you keep the marijuana plot limited to a 25-foot space. Whatever you harvest from that 25-foot space, you can keep all that. There's been some confusion. They say, well, you can possess an ounce, but what if you grow more than an ounce in your 5 by 5 foot space? That's actually not complicated at all. You can keep what you can grow. If you're not growing, you possess up to an ounce. This is a mandate. Prop 19 passes by November 3rd. This is the way it is in the entire state of California. This is not up to the Attorney General to decide. This is not up to some renegade cop in LA to say, I don't like the law. It doesn't matter. This is the law. It applies to everyone who's over 21 and is within the limits set by the initiative. The second thing the initiative would do, and this is what people are talking about more and more. Actually, let me just say a couple more things about that. Why do we need to pass Prop 19? Why do we need to say up to an ounce is legal if you're an adult in California? After all, California already has Prop 215, which says if you have a medical recommendation, you're protected from arrest. We do have that, and that's great in theory. But it's estimated that 200,000 people in California have medical recommendations to use marijuana. It's also estimated by the federal government that 3.3 million people in California use marijuana. So Prop 215 is only protecting a very small slice of the pie of the people who use marijuana in California. And it's not halting a whole lot of people from being arrested, because we know that there were 61,000 Californians arrested in 2009, and that there was another 62,000 Californians arrested in 2008 for violating marijuana possession laws. That means they possessed less than an ounce of marijuana. Those were the two highest totals that have ever been recorded for marijuana possession offenses in the state of California. And of course, this is almost 14 years after California's passed Prop 215. We're talking about tens of thousands of Californians who are getting arrested and they are prosecuted because they are possessing up to or amounts under an ounce of marijuana in California. These individuals would be protected under Prop 19, as would many others, including anyone who grows marijuana. Growing a single plant for non-medical purposes in California is a felony offense. It's punishable by up to 36 months in jail. Cultivation by an adult in private is lawful activity under Prop 19. The other thing Prop 19 would do is it would allow for local governments, if they so wished to establish regulations licensing the commercial production and distribution of marijuana for retail purposes. Once again, this would be for non-medical people. This would be for anyone over 21. If the city of Oakland says, we want to license this facility to grow marijuana, to then sell marijuana out of this facility, as long as they were licensed and as long as they were compliant with the regulations of our local government, and as long as they were selling to people that are over 21 years of age, that would be lawful activity. That is the second aspect of Prop 19, and that's the one that I said a lot of people are spending more time talking about because there's a speculation as to how much money would that raise, how many different counties would do it, etc., etc. In my opinion, not a lot of counties would probably do it, at least not initially. It's a pretty radical departure to go from saying all use of marijuana is illegal, which has been the law in California since 1913, well preceding the federal government's prohibition, to now this is something we're going to tax and regulate and treat like alcohol. But I certainly do think there are going to be plenty of plenty of counties that are going to make that change. Now, real quick, that's